Good afternoon or good evening, depending on your time zone, and welcome to the third Global Experts Plenary on Realizing Indigenous Rights, Intergenerational Justice, and Rights of Nature in this biennial Global Online Symposium, Human Rights, Sustainable Development, and the Law 2026. I'm Advocate Muskan Singh, CISDL Communications Officer, and I will serve as one of your moderators for this plenary. What an excellent series of lectures and discussions we have enjoyed so far.
Hello and welcome to all registrants, particularly those still online late at night in your countries. I'm Yasmin Sayed, a CISDL Associate Fellow. Together with my co-moderator, it is my pleasure to introduce the chairs of our third Global Expert Plenary on Realizing Indigenous Rights, Intergenerational Justice, and Rights of Nature. Professor Maya Prabhu is a CISDL Lead Counsel for Health and Associate Professor of Psychiatry, teaching both law and psychiatry at Yale University. Professor Prabhu's cutting-edge research delves into global health, forensic psychiatry, post-traumatic stress disorder, and post-conflict situations, and issues at the nexus of health, right, and human rights. And it is an honor to welcome her. Professor Jorge Cabrera is a highly distinguished professor of law at the University of Costa Rica and serves as CISDL's lead counsel on biodiversity. A renowned international legal expert in biodiversity law, he has led many international negotiations on environmental and human rights issues, including serving currently as legal advisor for his country's National Biodiversity Institute. And finally, adversary Nishan is CISDL's lead counsel for peace, justice, and governance, a visiting fellow at the Raoul Wallenberg Institute and CEO of the World Future Council. He's also a laureate of the Weeramantry International Justice Award for his world-leading contributions to post-conflict justice and inclusion. Please, esteemed chairs, the floor is yours.
Thank you very much, Jasmine, and greetings to you all. It's been an incredible day so far. And if you're just joining, welcome to the Human Rights, Sustainable Development, and the Law 2026.
Hello, everyone, and thank you for joining us. Together with Advocate Nishan and Professor Jorge, I will be one of your chairs for this plenary. It is my pleasure to introduce our opening keynote speaker for this plenary, whose crucial leadership on behalf of courageous, highly climate vulnerable countries has been recognized in the highest of circles. The Right Honorable Ralph Regenvanu is the Minister for Climate Change Adaptation, Energy, Environment, Meteorology, Geohazards, and Disaster Management of Vanuatu and former Minister of Justice. He's one of the Pacific's most distinguished and passionate advocates for climate justice, Indigenous rights, and the rights of peoples of small island states. He's played a leading role in international negotiations and tribunals addressing those challenges. He is also a renowned champion for traditional knowledge, cultural heritage, and the rights of Indigenous and local communities at the international level. Right Honorable Ralph Regenvanu, the stage and the Zoom screen is yours for the next 4 to 6 minutes. Thank you so very much for joining us today.
Thank you so much. It's really an honor and a privilege to be here and just been given this award, which I humbly accept on behalf of the young people of the Pacific. And I want to talk about that journey that started in a classroom at the School of Law, headquartered in Port Vila, Vanuatu, the University of the South Pacific, and how they initiated and led a global campaign for an advisory opinion from the ICJ on the obligation of states to address climate change. As everyone is no doubt aware, this decision was handed down in The Hague in July last year, and the judges unanimously declared climate change as a quintessential universal risk. Quintessential not only in that it threatens all of us universally, but also because there's no other way to address or combat it other than universally. That is through international cooperation, and in particular, the international cooperation of states. The advisory opinion also confirmed what we small island states have been saying for decades, that states do have legal obligations to prevent significant harm to the climate system and that failure to do so carries legal consequences. So how did the Pacific students and the government of Vanuatu activate international law, including the International Court of Justice and the United Nations, to respond to the injustice of climate change impacts for those most vulnerable? I'm from the Republic of Vanuatu, which is a small island state in the Southwest Pacific Ocean, comprising an archipelago of about 80 islands and home to just over 300,000 people, over 90% of whom are Indigenous. And we have contributed almost nothing to the climate crisis. We are responsible, in fact, for about 0.0001% of global greenhouse gas emissions. And yet the World Risk Report has ranked Vanuatu as the world's most at-risk country to natural disasters and extreme weather events, making climate change the greatest ongoing threat to the well-being and livelihoods of our people and our ecosystems. This is not just for Vanuatu, though. The Pacific Island states in 2018 issued the Boy Declaration on Regional Security, which reaffirmed as its first statement that climate change remains the single greatest threat to the livelihood, security, and well-being of the peoples of the Pacific, and our commitment to progress the implementation of the Paris Agreement. So we're among the first peoples on Earth, the first nations on Earth, being forced to confront what runaway global warming actually means. Stronger cyclones, rising seas, damaged homes, salt water displacing critical freshwater lenses on small islands, forced relocation, and the possibility that entire cultures may be pushed away from the places that made them. As Indigenous peoples, our identity is located largely in the landscape, which operates as an index to our history and our cultural memory. And when that landscape is eroded by seas, we lose more than just territory. So we've known that climate change was our greatest threat decades ago. My country, Vanuatu, became independent from our colonizers, Britain and France, in 1980. And immediately we became known regionally for strong anti-colonial positions in international relations. In the lead up to the first United Nations conference to address climate change at the beginning of the 1990s, Vanuatu, through our ambassador at the United Nations in New York, was part of a push to establish what still remains the most ambitious group of states in the United Nations Framework Convention on Climate Change negotiations, which is AOSIS, the Alliance of Small Island States. Our inaugural ambassador, Robert Van Lierop, became the inaugural chair of AOSIS. And acting as the founding chair, Vanuatu first brought up the concept of climate loss and damage at the United Nations in 1991, introducing the proposal to the Intergovernmental Negotiating Committee of the UNFCCC, with a submission that proposed an international climate fund and an international insurance pool to compensate vulnerable nations for sea level rise damages. This early proposal laid the groundwork for the eventual establishment of the Global Loss and Damage Fund at the UN Climate Change COP in Sharm el-Sheikh in 2022, 30 years later. And I was privileged to be there when this was decided. But this encapsulates the problem we face in the Pacific and for all of us in the world. Our existential challenge, our greatest national security threat, there is no action at international level commensurate with what we are seeing. For decades, for 3 decades now, global climate politics has been dominated by voluntary pledges, delayed promises, and carefully worded agreements that too often allow the largest emitters to move at the pace they find convenient. And generations of Pacific Islanders have witnessed this. Our leaders continue to fight for stronger action, meaningful action, but continue to face this political maneuvering and outright lies and refusal to act from high-emitting states. In 2015, Pacific leaders were instrumental in achieving the landmark Paris Agreement, which includes the commitment to the 1.5-degree temperature goal and a commitment to climate finance, a commitment by high-emitting states to provide funding to assist low-emitting, highly vulnerable states to adapt to the ravages of climate change. And so the Paris Agreement was signed on to by over 190 states. But within a few short years, it became clear that the developed states that were required to cut emissions to achieve the 1.5-degree goal and to provide the finance to a target of US dollars 100 billion per year were not doing what they had agreed to in Paris. Worse, emissions were actually climbing. So this is the situation confronting the students at the law school of the USP. when they revisited the idea of seeking an advisory opinion from the ICJ, they did not stop in the classroom. They went on to form the lobby group Pacific Island Students Fighting Climate Change, PISFCC, and began their lobbying effort by writing to governments of the Pacific Island states. And this is where I entered the picture. I was Minister of Foreign Affairs in 2019 when I received a letter from these students, the same letter they'd sent to the other leaders in the Pacific. And as an alumni of the law school, I agreed to meet the students, and I met a group of them in the first half of 2019, about 10 of them. They were amazingly inspiring. And I was inspired to take their request to the Pacific Island Forum Foreign Ministers meeting in July of 2019, and then to the Pacific Island Forum Leaders Summit in August 2019 in Tuvalu, which is one of the most vulnerable countries to climate change. And then in the second half of 2019, I accompanied Julian Aguan, who is the principal of the Guam-based law firm Blue Ocean Law, and he was the principal lawyer who took our case for Vanuatu at the ICJ, and Dr. Margaretha Weeramantry Singh, assistant professor of public international law at Leiden University, but also had previously served as a senior lecturer at the USP Law School. And we were able to go and find the funding from philanthropic sources that we needed to take this case. And in 2020, we officially engaged Blue Ocean Law Firm, an indigenous law firm based in Guam, and began the legal and diplomatic work. And I want to thank everyone who's online, probably the international legal scholars who collaborated with us in this case. So then it became a job of writing the question that would be put to the General Assembly to ask of the ICJ. And we established a core group of states representing all regions of the world, working with our legal team, working with our diplomatic team, and the challenge being to retain the integrity of the question that would get the answer we wanted, while gaining the maximum possible support from states. This core group worked on this question with all the international scholars who collaborated with us, and this was finalized during COP27 in November 2022. The question we got was probably 90% of what we wanted or more in terms of integrity. And it was the first, when it was put to the General Assembly on the 29th of March 2023, it was the first ever request for an advisory opinion from the ICJ that was referred by the consensus of the General Assembly without dissent. And this is a huge landmark in terms of achieving a global consensus on climate change. I want here to acknowledge the global movement of young people, the world's youth for climate justice, which was instrumental in getting states around the world to support this resolution, to vote for it at the General Assembly, to not vote against it at the General Assembly. And I want to acknowledge and laud their transformative role in getting this ICJ advisory opinion. So following the referral by the General Assembly, of course, the written submissions were made, the evidence collected, and in oral submissions in December 2024, I had the honor to be the first speaker in the case, speaking for Vanuatu and the Melanesian Spearhead Group in a case that went on for about 2 weeks. So as we know, a historic advisory opinion has been delivered, which authoritatively sets out states' legal duties in relation to climate change, and it clarifies key legal duties of states. And I won't go into the outcomes of that. I think many of us know what they said. Very strong findings concerning states sponsoring fossil fuel production, consumption, and granting of exploration licenses or provision of subsidies as an internationally wrongful act, which gives us a lot to work on in terms of the negotiations going forward. The vote to accept the advisory opinion was the next step we had to take. We went back to the United Nations in New York, re-established another core group. This time we left out the states that had not presented supportive arguments at the ICJ. This effort was carried out from the beginning of this year. It was a much more difficult effort. The consensus we had achieved in 2023 was no longer possible, and the whole multilateral system was becoming very confrontational. This is post to the second election of Donald Trump. We've had, as soon as we announced that we were bringing in a General Assembly resolution to accept and adopt the advisory opinion, we received a démarche from the US saying withdraw, and also all states were approached by the US saying they should not vote in support of this Assembly resolution. We had a group of states aligned against us in the negotiations of the text of the resolution, but we persisted, and I'm very pleased to say that on the 20th of May, just 2 months ago, we had a vote, 141 in favor, only 8 against, and 28 abstentions. So very strong support for this advisory opinion issued by the ICJ, and very comforting to us who are seeking international acknowledgement of the legal accountability of states for taking action on climate change. So we are moving climate responsibility from political promise to legal accountability. So while we are reluctant as small states to initiate international contentious litigation against other states, it's a route fraught with sovereign risk, especially given the current global adversarial climate. Also, initiating international contentious litigation against a fossil fuel major is also a significant financial risk for a small state. There are states who are talking about this, but I just want to give a number of ways in which I think we should be working forward with this advisory opinion. I've always said that probably the most important effect of the advisory opinion will be that it will strengthen climate litigation in jurisdictions all around the world. And we saw that immediately in August last year, immediately after the advisory opinion was handed down. We saw it being used in a case in New Zealand, and now we're seeing it being used in cases all over the world. This UN General Assembly resolution welcoming the ICJ also gives more weight to this advisory opinion to help argue that governments must cut emissions, regulate polluting industries, and prevent climate harm. Secondly, I think it has made fossil fuel expansion legally riskier. So this opinion has strengthened the argument that states must regulate these private actors under their jurisdictional control. Thirdly, for us in the negotiation space, it's strengthened the language of climate diplomacy. For years, governments have talked about ambition, which sounds noble but is optional. Obligation is different because it implies responsibility and consequence. So in the Pacific, we are now holding workshops with Attorney General's departments and ministries of justice to identify how we can strengthen our legislation, our constitutions as appropriate, to domesticate the advisory opinion, particularly the right to a healthy and sustainable environment for our peoples, for our communities. It means ensuring that our traditional authorities, our youth and women and communities are fully part of these discussions. And this is something we've been doing in Vanuatu through consultations. And at a regional level, we're trying to build coherence and collective ambition to make sure the Pacific continues to lead in pushing the world to more effective climate action. Thank you.
Thank you so very much. That was inspirational, and I cannot wait to return to your comments in the question period. I believe that will be, sorry, Nishan. Sorry, my apologies. Jorge? We may have lost Jorge. All right, with Jorge's permission, I will say thank you for your compelling remarks. And as I said, I look
Sorry, my microphone was mute. but sorry, Maya. Yes,
Not
thank
at
you.
all.
Okay, yes, sorry. Thank you very much, Dr. Uh, Banu, for your very interesting and compelling remarks, which clearly opened the floor for to an excellent conversation in this session. It's very nice to hear about your experience, your personal experience involved in the process of advancing the advisory opinion before the International Court of Justice. It is very clear for us here in Latin America that this advisory opinion has been really a landmark decision and has been also supportive, a milestone in the development of international law in the field of climate change and human rights. And thank you very much for your explanation about that. We have three focus questions that we especially hope we'll be able to discuss, and we will invite each of you to also type your own questions for our speakers into the Q&A system, ensuring please that you can provide your name and country. The three focus questions that we have are as follows. Um, Please consider how to strengthen recognition and respect for Indigenous peoples' collective rights worldwide, including through the role of international law, advisory opinions, of course, and human rights opinions in this region. I mean, in Latin America and the Caribbean, especially the climate change and opinion C 32 2005 of the last year. Please feel free to try to respond to that. Also, what can international law, how can international law contribute to advance and securing intergenerational justice and the rights of future generations, including the rights of children to participate in decision making and in other processes that can affect them, including the right to a healthy environment. And finally, and very important as well, how is the law advancing to recognize, this is a very relevant concept and established in many constitutions, including in this region in Bolivia, in Ecuador, and in other practices, the rights of nature and what implications does this uh, have for the human rights uh, and for sustainable development in the light of, again, of these new advisory opinions in the human rights courts that are creating this type of hybrid um, rights. I mean, this mix between rights of nature and human rights. Uh, and I think I will
Thank you, Professor
pass
Hore.
now to Nisham. Yes.
Thank you. Let us now turn to our expert speakers, whom it is an honor to introduce. Dr. Pamela Tovelo Sambo is an associate fellow at the CISDL and an academic at the University of Zambia, as well as highly distinguished commissioner with the Human Rights Commission of Zambia. Her research focuses on international human rights law, sustainable development, and access to justice in African countries. Then we have Advocate Nina Pindam, who is a renowned barrister with the Cornerstone Climate and member of the UK Employment Lawyers Association. She specializes in public law, human rights, and environmental law, with a particular focus on climate litigation and the rights of workers and communities affected by the energy transition. Dr. Daniel Ruiz de Garibay is coordinator of the Center for International Sustainable Development Law, Biodiversity and Law and Governance Initiative, and a researcher at the Asia Pacific University of Technology and Innovation with expertise in the law of nature's rights, biodiversity governance, and indigenous peoples' rights in the Asia Pacific. Advocate Emily Julier is a leading lawyer with Hogan Lovells of London with outstanding expertise in international human rights law, indigenous peoples' rights, who has been active in international forums on the rights of nature and future generations. They have kindly agreed to limit their initial remarks to 3 to 4 minutes in order to permit more rounds of engagement with your questions online. So please do enter them with your name and country into the Q&A. And it is again a pleasure to have you all with us. I believe Dr. Pamela is still not here. Till she joins, may I ask Nina for you to commence with your your responses?
Thank you, Nishan. And to those who've been here for the whole day, goodness gracious, going to conferences is a byproduct of my job as a lawyer and chair of the UK Environmental Law Association. But this is one of the finest and most thought-provoking I've ever attended. So thank you very much, Marie-Claire, for setting this up. Some really interesting lessons from this morning that I'm going to tie into my comments. And I've been looking at the Q&A, so I'm going to address as many of those questions in my 3 minutes. So here we go. That the International Law Commission, it has confirmed that they're going to treat the ICJ advisory opinion as a source of law in its own right. Hooray for that. That the idea of non-regression of environmental protection means maintaining pace with the best available science. I can absolutely see that being taken forward in litigation across the world. So thank you very much to Judge Salvo for introducing me to that concept from the Hungarian Constitutional Court. Why conferences like this are so important. So to do honor to those big ideas and to the inspirational Dr. Regenvanu, I'm going to provoke this discussion and kick it off with a big idea of my own that I've been thinking of for quite some time, which is the rule of law. So we all know as environmental lawyers or environmental law adjacent people that there has never been a more important time for environmental law ever in human history. To that end, with the brilliant Emily Bradeen of the Grantham Research Institute at LSE, we looked at the domestic implementation of the ICJ advisory opinion, and it's very clear that will be published in time for the 1-year anniversary. It's very clear there's pre-ICJ advisory opinion domestic litigation and post-ICJ advisory opinion domestic litigation. So Dr. Regenvanu, thank you. It's a new world and courts are rising to this challenge. So the big provocation that I'm going to put out there about the rule of law and the environment arises from the book, Rule of Law, the classic text now on Rule of Law of Lord Bingham, where he concluded that the protection of the rule of law requires protection of fundamental human rights. And that is now fairly uncontroversial as a judicial principle and also as a principle aligning with the rule of law. The ICJ advisory opinion confirmed that a precursor for the enjoyment of a range of human rights, fundamental human rights, is protection of the environment. As they said at paragraph 373, that the environment is the foundation for human rights for both present and future generations. Thus, I would argue the rule of law requires protection of the environment. That's a big idea. I'm here to speak about legal advances to protect nature, and that's a component of that big idea. One way we do that here in the UK is to treat nature as a form of infrastructure. That is recognised by the UK government in terms of critical health metrics. So access to nature is now being treated in law as a measure of communities' health. So the UK Environmental Improvement Plan commits the government to policy of ensuring that every human being within the UK has access to green or blue nature within a 15-minute walk. And they are being held accountable to that by Parliament. That's critical, this accountability mechanism. The UK is also brought in through England predominantly, shortly hopefully to be disseminated to devolved governments, the idea of biodiversity net gain. And this is again another accountability mechanism where developers are being made accountable for harm to biodiversity. In a nutshell, the biodiversity value of a site is measured prior to development, and then the developer is committed to providing 110% post-development biodiversity on the site or outside the site. That's long been policy in the UK, but the key point I want to make about that is that it is now law. And the game changer was when that policy became law, because when it was policy, it was treated as an afterthought, a nice to have, biodiversity net gain. But now that it's legally mandated, and there is a measurable mechanism for that, which is called the statutory biodiversity metric. So because it's law, because it's now measurable, it has been a complete game changer, and developers are now engaging ecologists at the very beginning of even considering a plot of land. So really, really important principles there. And if I can end by quoting, I think, one of the finest lines ever written in a judicial opinion ever in history. This is Lord Leggett speaking for the majority in the Supreme Court decision of Finch and Surrey Council here in the UK. You can only care about what you know about. So accountability, measurability, and implementing that through law. Those are the three big ideas in terms of protecting nature that we're advancing here in the UK. And it's a really exciting time to be a nature lawyer.
Thank you very much, Nina, for those comments and responses. I think that sets the tone very well. Could we now move to Emily for your comments?
Hello, and thank you so much for inviting me today amongst all of these very learned and amazing other speakers. I'm Emily Julia. I'm counsel knowledge lawyer at Hogan Lovells Cadwallader, and I'm a solicitor in England and Wales. And my practice has been traditionally in international finance, and I work in sustainability investment and sustainability finance. But my intervention is about rights of nature, and I see them to be integral to the importance of all of the other questions here, the importance of ensuring that Indigenous peoples are included, that their values are included and valued by others, to sharing the amazing knowledge that they have. Also, nature is obviously extremely important. We are all dependent on nature. And so it makes complete sense, if you are thinking about intergenerational justice, to make sure that perhaps we have some nature left for the generations to follow. And so for me, it's completely part of the same question that we're asking. I have some experience in relation to rights of nature in my own way in the UK, but I thought that maybe I would just do a little very quick explanation of how it has developed internationally very, very quickly, and then talk about what we're doing here in the UK. So rights of nature, of course, been around for a very long time. They have come to the notice of people in the UK, and I think people within the kind of Western legal system in the US in the last 20 years or so. And rights of nature in the UK are definitely coming from a grassroots local level. People are looking at rivers and nature and seeing that we're in the most depleted place for nature in the UK, and seeing what we can do to solve that. And so, as has already been mentioned, Ecuador, Bolivia, and I think Ghana as well have in their constitution rights of nature. Other countries have elements of rights of nature in their constitutions as well. So you can look at this from a constitutional point of view, but also there are many countries which are including rights of nature within statutes as well. So, for example, New Zealand and also Australia are all giving legal personhood to rivers, mountains, forests. In the UK, we do have a bill that is going through Parliament at the moment for rights of nature, but we have been recognising rights of nature through local government, and then using that lens of rights of nature to integrate and change the way that people make decisions. Thank you.
Thank you very much to both of our panelists who, oops, I may have inadvertently raised my hand, but I am full of questions. But I'm going to take the moment here to move to our from our distinguished experts to our other keynote remarks. Professor Wayne Garnons-Williams is the founding president of the International Intertribal Trade and Investment Organization. He specializes in Aboriginal and environmental issues with expertise in corporate, commercial, and trade law. Professor Garnons-Williams has extensive experience in both corporate and government sectors, focusing on promoting Indigenous trade and investment opportunities. He serves as CEO of the National Sixties Scoop Healing Foundation of Canada, a nonprofit registered charity, and previously served as the chair of the Federation of Saskatchewan Indian Nations Appeal Tribunal. He also served as leading negotiator of the Indigenous Peoples Economic and Trade Cooperation Arrangement. Professor Garnons-Williams, the Zoom screen is yours.
Thank you very much. Wonderful discussion so far. I want to, first of all, congratulate the Right Honorable Ralph Reagan Vandu for his great initial provocation and his great remarks. I'm seeing a theme here throughout the whole conference here, and this is the theme that I kind of jotted down just thinking about this was we're moving from international legal principles, which we cumulatively come together as a group and we hammer out all our perspectives on this in an international body. And then we evolve that to try and make these great ideal international legal principles domestically enforceable in our own nation states. And Ralph referenced that with respect to the ICJ advisory opinion, trying to make this enforceable domestically by looking at the rights to a sustainable environment. We've seen that theme happen throughout. And I think it's really interesting to note that we're seeing that also crop up in other places as well. For example, in I'm Canadian. There's a case in the British Columbia Court of Appeal, the Kitskala case versus British Columbia, and it takes basically this whole concept of what do we do when we make something domestically enforceable that has potential environmental implications and Aboriginal right implications in relationship to the rest of the current judicial legal body out there. And the Gitsala case was the first time that, for example, in Canada, as you know, the United Nations Declaration of the Rights of Indigenous Peoples, I believe all countries became signatories, but Canada took it a step further and became, first of all, British Columbia became, made it domestically enforceable by law, and then Canada made it domestically enforceable by law. So this case basically is, there's a mining act in British Columbia. It ran afoul of UNDRIP, and the court came down and basically really enforced UNDRIP in a way that had never been done before, where there's a bunch of legal principles that are teased out, which are really important so that they give meaning and depth and grounding to UNDRIP, and not just fancy words that are promises made by politicians, but are actually impacting legislation. For example, the Mining Act, where sections were read down in comparison to the importance of the principles in UNDRIP and domestically enforceable law of UNDRIP. So it's really a kind of overarching theme that we're seeing where these international principles like UNDRIP or like Sustainable Development Goals, we need to find ways we can make them domestically enforceable in nation states around the world so that we can move these forward to get real results on the ground. And again, I want to go back to Ralph's comment about the fact that I could feel the frustration of the political goodwill that's out there, but it's the need to actually get results on the ground and the urgency of Vanuatu and other small Pacific Island nations that are most vulnerable. So the idea of actually getting results, getting domestically enforceable results from the work we do in finding consensus with respect to international instruments that we can use globally to make them and get the goodwill in nation states domestically to make them domestically enforceable. That's, I think, a really cool theme that is evolving from this discussion. So that's my intervention. Thanks.
Wonderful to hear from you, Professor Wayne Garnons-Williams, and thank you for these stimulating contributions. We turn briefly now to two interveners. First, Advocate Laura Duarte is Senior Legal Executive with the Net Zero Lawyers Alliance and Associate Fellow at the Center for International Sustainable Development Law. She has served as Associate to the Chief Justice of the Supreme Court of South Australia and has worked extensively on public interest, environmental, and human rights law. Then Ella Martinez is a Center for International Sustainable Development or researcher and manager of the Voices for Future Generations program, focusing on intergenerational justice, children's rights, and the participation of young people in sustainable development law and policy. Advocate Laura, your intervention, please.
Thank you very much, everyone. And thank you again for your wonderful interventions so far. I should say that I am on maternity leave at the moment and a free agent, not at NZLA, but will be rejoining my law firm in Australia. So the question is this: how are legal systems reconciling existing environmental laws with Indigenous rights, Indigenous legal traditions, and the rights of nature in a way that is respectful and meaningful? In other words, what are your success stories that you would like other domestic lawyers to know about? Because as Advocate Nina Pinham said, you cannot care about what you do not know about. We would love for the pollination of legal strategies to occur today.
Thank you very much. Laura, over to you, Ella.
Thank you very much. Hello, everybody. Thank you so much, distinguished chairs and experts, for your insights. It's been really wonderful to hear about the advances in terms of climate change, justice, as well as the efforts still ongoing. My question is, well, Indigenous peoples globally have been at the forefront of activism to acknowledge and honor the rights of nature. On the other hand, the rights of nature have been many times weaponized by colonial powers and states to restrict Indigenous peoples' access to their ancestral lands and the ecosystems they've historically depended on and stewarded. A couple of examples are the expulsion of Indigenous communities from Yellowstone National Park in the US at its creation, and the Israeli Nature Patrol's persecution of Palestinian foragers of Aku, a traditional practice in the name of quote-unquote conservation. So my question is, how is the relationship between the rights of nature and the rights of Indigenous peoples to land recognized or not still in current legal instruments and policy conversations? And how can this relationship be leveraged in efforts to continue advancing reconciliation, intergenerational justice, and the rights of nature? Thank you.
Thank you very much, Ella, and again, Laura, both important and deep questions. At this stage, may I ask our respected plenary members to respond to either of the question or both? Yes, Nina, may I ask you to proceed? Go ahead.
Sure. I mean, I get paid to talk for a living, so it's not surprising that I jump in first to contribute. I'll address the second question because that's something that's been concerning those of us who work in climate and nature law quite a lot, which is the emerging trend that we're hearing in carbon market discussions where Indigenous rights are being ignored, if not completely overridden by a lot of money coming in to purchase carbon credits. And there is this horrible green on green, I hate that term, but there is very much a decoupling of environmental protection and the advancement of Indigenous people's rights in that respect. So there is work being done at the UN level to coordinate the 3 Rio conventions, the Desertification Convention, the Biodiversity Convention, and the Climate Convention, in light of what they know is this problem, not only this one distinct instance of carbon markets, but across the piece where there is a lack of coordination. So that's in progress. So just being aware of what else is happening and not undermining one effort to protect the environment through another effort to protect the environment, and to do so in a way that is cognizant of everybody affected by that action. One way that's being done in a really interesting forum is through the Biodiversity Convention. And I believe a friend of CISDL, Harriet with WWF, is really thoroughly involved in this, which is the other effective areas of conservation. It's a mouthful of an acronym, but it's looking at, instead of preserving nature in aspic and drawing a line around it and saying, you can't be here, you can't do anything here, Indigenous peoples, sorry, this nature is more important than your rights. It's working in conjunction with Indigenous peoples who are inhabiting that area to develop long-term conservation measures without that old school type of nature protection, which is we draw a line around it and we keep it forever pristine, which we all know is not possible and not an equitable way to go forward with nature conservation. So that's one example where I think we've got really exciting things happening. And congrats to Harry for getting that on the agenda at the UN level and going ahead with it. So that's my example of something positive coming out of this. But there's a lot of work that needs to be done.
Thank you so much.
Thank you, Nina.
Thank you, Nina. You know, we're very fortunate that one of our experts who wasn't able to connect earlier has now been able to join us, Dr. Pamela. Dr. Pamela, thank you for connecting with us. Dr. Pamela Toela Sambo is an associate fellow at the CISDL and an academic at the University of Zambia, as well as a distinguished commissioner with the Human Rights Commission of Zambia. Her research focuses on international human rights law, sustainable development, and access to justice in African countries. Dr. Pamela, we're so glad you're able to join us. Perhaps we can invite you to deliver the comments you were going to make a few minutes earlier now, and then we'll continue with another round of moderated questions.
Okay. Thank you very much, colleagues, for that opportunity and for the kind introduction. My apologies that I had network challenges, couldn't come in on time. Looking at the important subject that we have, and I'll just make my comments in view of all the three questions to just try and see in case a number of issues have already been raised before I joined. But when we look at the intersection of the importance of Indigenous rights, local community rights, intergenerational justice, and the rights of nature, we see that they cut across all the SDGs, really. And this is an important foundational issue for overall environmental governance across the globe. When we look at country specifics, region specifics, I think one of my colleagues has already talked about the issue in terms of how we can relate it to climate justice, especially in the context of perhaps most of Southern Africa, where we see that the issue of addressing carbon markets, carbon credits, it's affecting the issues and the rights that we have amongst our Indigenous peoples, the local communities. How exactly are we dealing with these issues, and are there mechanisms that have already been internalized in the different local communities across the globe? How are we monitoring? How are we tracking how the overall picture affects the rights of Indigenous persons from different perspectives of environmental governance? And when I say environmental governance, I add all the different aspects that make the environment a joint whole. So I just gave an example of how we are addressing particularities concerning Indigenous peoples with regard to climate justice in the context of carbon credits. I think this is an important issue that needs to be looked at also from how it affects the exercise of human rights across the board. Because in terms of accessing the goods of the environment, all the Indigenous and local communities must be capacitated in such a way that they are able to get benefit of all the different aspects of the environment that are available to them. And in the larger context of looking at rights of nature, we see that it includes mainly the global commons. And when we talk about the global commons, we look at the different kinds of environmental amenities that are reachable within particular communities. And right now, as the world is facing the triple planetary crisis, we see that isolating any of these rights of indigenous persons is an aspect that can contribute towards finding mechanisms of addressing the triple planetary crisis. So, in a nutshell, I just want to reemphasize that the discussion that we are having comes to the intersection of upholding all the sustainable development goals, even though we can isolate a few that are much more directly connected. I think for now, those are my remarks. Thank you.
Thank you. Thank you for making the effort to join us despite all the connectivity issues. And we appreciate those remarks. Perhaps we can return to our interveners who are asking rounds of questions. And Dr. Pamela, we invite you to respond to questions as they arise and are of interest to you. Thank you. Over to our moderators, Yasmin.
Thank you, Professor Prabhu. Me and Advocate Yasmin, we'd like to ask some questions. I'll go first, and then it'll be followed by Yasmin asking some more questions. So we've tried to collate all the questions into 2 questions from my side and 2 questions from Yasmin's side. So the first question that I wanted to ask is on behalf of Christine Ramacharan from Trinidad and Tobago, Ramos from Philippines, Kevin from Kenya, and Mustafa. They wanted to ask, how can international law and governments better recognize, support, and empower Indigenous people, particularly where communities have experienced historical erasure and marginalization, while complementing legal reform with broader social and behavioral change? The second question was from Mohammed Hassan from Bangladesh and Mansa Amoha from South Africa. They wanted to ask, how might emerging legal concepts such as the rights of nature and the right to a healthy environment be applied beyond climate change, including marine ecosystem and deep seabed mining? And how should these rights be balanced with the state's obligation under international law and the right to development? Over to Yasmin.
Thank you, Advocate Muskan. Omar Nasser from Lebanon, Ashish Bata from Nepal have asked about how young people can become more central to advancing climate justice and Indigenous rights, including through policy making and engagement with stakeholders, and how these international legal frameworks can be translated into practical action at the national level. We also heard from Zahra Khan from Dubai, Dr. Abdul Lamin from Senegal, who have expressed curiosity about the role that international and regional courts should play in advancing climate justice and human rights, and how effective litigation, advisory opinions, and regional judicial mechanisms are in influencing states and delivering accountability. Thank you.
May I come in?
Please.
Thank you. The second question on how we can look at rights of nature promotion beyond just climate justice. I think this is a point I can pick on from what I was saying initially, where I mentioned the triple planetary crisis, because now when we look at rights of nature, and if globally and within the respective jurisdictions, we could move towards harmonizing them in our local legislation, these are aspects that can lead us to better outcomes when we look at addressing loss of biological diversity. We look at pollution control. We also look at more specific aspects of the environment, like promoting water justice, because all these flow from protection of rights of nature. So indeed, these are issues that can move us beyond climate change, but helping us tackle one of the most crucial problems we have right now, the triple climate problem, the triple planetary crisis. Thank you. Thank you. That is all I will say for now.
Thank you. Moderators, I don't want to step into your role here, but we have lots of hands up.
Professor Wayne?
Thank you. Yeah, I want to address one of the questions from our audience of how can we bring these principles forward? What can we do to enforce these things? And part of the process, of course, it's an iterative process. One has to first of all gain consciousness of other bodies, other jurisdictions that are working on these problems, educate your domestic legislators, and bring these to bear. I'm going to go back to the case in Canada, the Gitsala case, the BC Supreme Court case, which is just one level below our Supreme Court of Canada. And it's a part of it, the decision dealing with the United Nations Declaration of the Rights of Indigenous Peoples. I just want to raise this one thing that the court said, and this is really important. The court said free, prior, and informed consent is not a single chapter in the United Nations Declaration of the Rights of Indigenous Peoples, but a foundational principle integrated throughout the document, primarily represented by key articles that establish the right to participate in decision-making and control over lands, resources, and territories of Indigenous peoples. And that's really important, the fact that this is being interpreted and enforced. This what started out as an international concept, debated and hammered out for over 30 years in the United Nations, now is domestically enforceable in Canada, where we've got judges making really cool decisions of how to interpret this. And then these decisions, while not binding in other places around the world, are informative and educational and useful. Another one, just my second point, and I'll be brief, is again, international instruments that are already out there, they're being used, like IPECTA, the Indigenous Peoples Economic Trade and Cooperation Arrangement, where this international Indigenous trade agreement defined what Indigenous trade is. And when you look at the definition, it's not your mom and pop's definition of what Indigenous trade is. It's an Indigenous-made definition, and it includes, and I quote, the responsibility of Indigenous peoples to protect their lands, resources, and the spiritual interrelationship of the human and natural world, as well as the integrity of the natural systems themselves. That's part of Indigenous to Indigenous trade, is respecting the environment, protecting the environment, but also providing livelihood and trade. So the world can take these instruments and learn from them, and maybe like we're seeing in a theme, make them domestically enforceable in various jurisdictions around the world. Thanks.
Thank you, Professor. Over to you, Professor Hore.
Yes, thank you very much. I would like to address a little bit the question about the use of these advisory opinions of international law in domestic courts. For instance, here in Costa Rica, after the adoption of the decision of the advisory opinion for the Inter-American Court of Human Rights, C-32-225 on climate change and human rights, the Constitutional Court of Costa Rica have quoted and used this decision at least twice. So for us in Costa Rica, I think this is not really a big issue. So now that the advisory opinion has been adopted, it will be used in the future in several times, I'm pretty sure, and has been used in 2 times after the adoption of the decision in the last year. In my view, this is in some countries more or less a common practice. Unfortunately, in the case of Costa Rica and in other countries, these decisions are written in Spanish, so are only available in Spanish. This is a major problem in the sense that they're not fully disseminated, but they are there. So this is the case of Costa Rica. And regarding the right of nations, is more or less the same. We here in Costa Rica, we have several constitutional court decisions addressing the issue of right of nature. The most important one, unfortunately, decided to deny the idea because of other legal components of the system in Costa Rica. That was targeted to a river. The water and the rivers in Costa Rica are under public domain, so are under the control of the state, so that there will be a contradiction of declaring the rights of nature of a river and at the same time establishing that the water it's owned by the state. But in other countries like in Ecuador, especially, and in Colombia, there are many jurisprudence regarding the rights of nature and regarding the use of advisory opinions and human rights in the constitutional court decisions. So I think perhaps we need to try to, um, to find ways to share these decisions more widely so that other regions can be informed by that. But there are many, so this is nothing new for this region, for Latin America and the Caribbean, at least for Latin America.
Thank you, Professor Jorge. Advocate Nina, maybe you can go now. Thank you.
Thank you so much. And I'm conscious of the time, so I'll be quick. The sort of to riff on what Professor Gavin Williams said about the need to bring this home in a way, domesticate the principles articulated in the ICJ advisory opinion. I think what it's done and how, because the question goes to, well, how do you do that? What's the hook? I'm not an international lawyer by trade, so the customary international law aspect of that will be dealt with elsewhere. But in terms of legal culture, I think it's three things that I want to mention that I think are really important and can be overlooked in the technical legal arguments about how you get that hook, that domestic hook. So the first one is that the climate change as a legal concept disrupted a lot of established legal concepts. So the courts were sort of reluctant to delve into it. And they said, this is a political question, hands off, we're not touching it. That's changed now. So one of the ways that the ICJ advisory opinion has helped to the courts grapple with this is by firmly establishing the factual foundation for these types of cases, which is the IPCC report. So that's, the facts are established. It's the IPCC reports. Good. That's done. The courts can now get on with it. Second thing that the ICJ advisory opinion did is it structured and sort of systematized quite a lot of public international law on the basis of that factual foundation. So it's given us a really helpful framework for articulating and debating and deciding these cases now. So the courts are less hands-off. They know what to do. They've been given the tools to do so by the ICJ advisory opinion. And the third thing that's really, really critical is that legal culture has now shifted. It really does feel like we're on the other side of a very difficult hill to have climbed up, us as climate litigators. So legal culture is now, it's got this framework to deal with these cases. We're getting the case law to populate that framework. And legal culture influences legal interpretation. So the cases that Professor Gagnon Williams were speaking about were instruments of interpretation, given the toolbox of domestic legislation in those cases, granted. But legal interpretation, how the cases are framed, how they're determined, all of that is influenced directly by the ICJ advisory opinion. So it really is a game changer for domestic litigation, quite apart from that direct hook of this is being implemented through X law. So just to set aside the technical arguments there. And sorry, moderators and chairs, I've gone off quite a bit longer than I intended to on that. Sorry.
Thank you so much, Advocate Nina. Just keeping in mind the time, over to Advocate Emily here.
Hi, thanks. And I will really be very brief. It just occurred to me that although the Inter-American Court on Human Rights did mention rights of nature, it wasn't really covered in the ITLOS or the ICJ advisory opinion in a helpful way. And also thinking about the way, and this is very UK-based, that the UK government hasn't been very open arms welcoming to the idea of rights of nature. So in those countries where that is the case, it's really interesting to see that this is where we're seeing a welling up of local people really kind of pushing this forward and really wanting to use it to improve their environment and perhaps really connect with nature again. So in a funny kind of way, in this particular instance, I think it's more that international law, instead of being put into domestic, maybe needs to go the other way up again to meet in the middle here.
Thank you all for your questions, and thank you so much for your answers. As we are mindful of the time, can we move to Professor Jorge? Professor Jorge?
We might ask
Sorry,
Professor
sorry.
Maya to
Here it
step in.
goes.
I'm sorry. Okay. Yes, thank you very much for all the speakers and interveners and all the participants. Their comments very, very useful, and I think it's very good to have this kind of feedback and input. I'm really grateful with the keynotes, the speakers, the interveners, and all the audience for sharing their wisdom and your vision and your ideas and experience with us, especially in issues relevant such as the implementation of into domestic law of these international developments, like in the case of Costa Rica, I mentioned it has been done, been achieved, and in other countries like I am aware. I think this concludes our third expert plenary today. I'm really invite you to continue, please, in the Closing International Roundtable. Continue joining us. This is an event of this year, and the next one will be prepared in 2 years, in 2028. So please continue. I really appreciate all the participants, all the speakers, all the keynotes for their interventions. And I think it has been a very, very useful exchange of ideas about international law and domestic law. Thank you very much.
Let me also add my sincere appreciation to all the contributors. It's been incredible. Looking forward to the closing.
Thank you, everyone, from me as well. We look forward to seeing you in our closing round table coming up next.